We'll hear argument this morning in Case 23-719, Trump versus Anderson. Mr. Mitchell.
Mr. Chief Justice, and may it please the Court. The Colorado Supreme Court held that President Donald J. Trump is constitutionally disqualified from serving as president under Section 3 of the 14th Amendment. The Colorado Supreme Court's decision is wrong and should be reversed for numerous independent reasons. The first reason is that President Trump is not covered by Section 3 because the President is not an officer of the United States, as that term is used throughout the Constitution. Officer of the United States refers only to appointed officials, and it does not encompass elected individuals such as the President or members of Congress. This is clear from the Commissions Clause, the Impeachment Clause, and the Appointments Clause, each of which uses officers of the United States to refer only to appointed and not elected officials. The second reason is that Section 3 cannot be used to exclude a presidential candidate from the ballot, even if that candidate is disqualified from serving as president under Section 3, because Congress can lift that disability after the candidate is elected, but before he takes office. A state cannot exclude any candidate for federal office from the ballot on account of Section 3, and any state that does so is violating the holding of term limits by altering the Constitution's qualifications for federal office. The Colorado Supreme Court's decision is no different from a state residency law that requires members of Congress to inhabit the state prior to Election Day, when the Constitution requires only that members of Congress inhabit the state that they represent when elected. In both situations, a state is accelerating the deadline to meet a constitutionally imposed qualification and is thereby violating the holding of term limits. And in this situation, a ruling from this Court that affirms the decision below would not only violate term limits, but take away the votes of potentially tens of millions of Americans. I welcome the Court's questions.
Mr. Mitchell, would you you didn't spend much time on your argument with respect to whether or not Section 3 is self-executing. So would you address that? And in doing that, your argument is that it's not self-executing, but then in that case, what would the role of the state be? Or is it entirely up to Congress to implement the disqualification in Section 3?
It is entirely up to Congress, Justice Thomas, and our argument goes beyond actually saying that Section 3 is non-self-executing. We need to say something more than that, because a non-self-executing treaty or a non-self-executing constitutional provision normally can still be enforced by a state if it chooses to enact legislation. The holding of Griffin's case goes beyond even that by saying that a state is not allowed to implement or enforce Section 3 of the 14th Amendment unless and until Congress enacts implementing legislation allowing it to do so. So under Griffin's case, which we believe is correctly decided, the Anderson litigants disagree with us on that point. But if this Court were to adhere to the holding of Griffin's case, there would not be any role for the states in enforcing Section 3 unless Congress were to enact a statute that gives them that authority.
Counsel, what if somebody came into a state Secretary of State's office and said, I took the oath specified in Section 3, I participated in an insurrection, and I want to be on the ballot? Does the Secretary of State have the authority in that situation to say, no, you're disqualified?
No, the Secretary of State could not do that consistent with term limits, because even if the candidate is an admitted insurrectionist, Section 3 still allows the candidate to run for office and even win election to office, and then see whether Congress lifts that disability after the election. This happened frequently in the wake of the 14th Amendment, where Confederate insurrectionists were elected to Congress, and sometimes they obtained a waiver, sometimes they did not, and each House would determine for itself whether to seat that elected insurrectionist, because each House is the sole judge of the qualifications of its members. So if a state banned even an admitted insurrectionist from the ballot, it would be adding to and altering the Constitution's qualifications for office, because under Section 3, the candidate need only qualify during the time the candidate holds the office to which he's been elected. And under Your Honor's hypothetical, the Secretary of State would be demanding, essentially, that the candidate obtain a waiver from Congress earlier than the candidate needs to obtain that waiver.
Well, even though it's pretty unlikely, or at least would be difficult for an individual who says, I am an insurrectionist and I had taken the oath, that would require 2/3 of votes in Congress, right?
Correct.
Well, this is a pretty unlikely scenario.
It may be unlikely, but no Secretary of State is permitted to predict the likelihood of a waiver, because in doing so, they're adding a new qualification to the ability to run for Congress. And the proper analogy, Mr. Chief Justice, is to state residency laws, because the Constitution says that a member of Congress must inhabit the state that he represents when elected. And the lower courts have all held, in reliance on term limits, that a state election official cannot move that deadline any earlier by requiring the candidate for Congress to inhabit the state.
So even if somebody comes in and says, I'm a resident into the Secretary of State's office in Illinois and says, I'm a resident of Indiana, I have been all my life, I want to run for office in Illinois, the Secretary of State can't say, no, you can't?
Well, the question would be, is that person going to inhabit the state when the election is held? So if the candidate makes clear, perhaps through a sworn declaration or through his own statements, that he has no intention of relocating to that state before Election Day, then the Secretary of State would be enforcing an extant constitutional qualification rather than enforcing a new state-imposed qualification. And that's the key under term limits. Is the state in any way altering the criteria for a federal office, either for Congress or for the presidency? And in this situation, the Colorado Supreme Court is going slightly beyond what Section 3 requires, because Section 3, on its face, bans an insurrectionist only from holding office.
Counsel, can I stop you a moment and back up a minute? You admitted that the concept of self-executing does generally permit states to provide a cause of action for breaches of a constitutional provision.
Correct.
In fact, they do it frequently for takings clauses. There's no debate that Colorado has provided that cause of action. You want to go a step further and say that this, like the treaty clause, requires implementing legislation to permit the state to disqualify an insurrectionist.
That's correct. So
under Section 3.
That's right.
So history proves a lot to me and to my colleagues generally. But there's a whole lot of examples of states relying on Section 3 to disqualify insurrectionists for state offices. And you're basically telling us that you want us to go 2 steps further. You want to maybe 3. You want us to say that self-execution doesn't mean what it generally means. You want us now to say it means that Congress must permit states or require states to stop insurrectionists from taking state office. And so this is a complete preemption in a way that's very rare, isn't it?
Well, that's the only thing I would disagree.
It's rare under the 14th Amendment.
Oh, of course it's rare. This is a one-off situation. And, Your Honor, the only thing
it is one-off. I don't disagree with you. But it's not with respect to how we've defined self-executing.
We're not asking this Court to redefine the concept of non-self-execution. We were careful in our brief not to rely on that phrase. And Griffin's
right,
case
you are because it's not.
That's right. And
okay,
Griffin's
so
case.
So now the question is a very different one in my mind. I understand what you're relying on, Griffin. Let's just be very clear.
Right.
Griffin was not a precedential Supreme Court decision.
That's correct.
All right? It was a circuit court decision by a justice who, when he becomes a justice, writes in the Davies case, he assumed that Jefferson Davis would be ineligible to hold any office, particularly the presidency, and treated, and this is his words, Section 3 as executing itself, needing no legislation on the part of Congress to give it effect. So you're relying on a non-presidential case by a justice who later takes back what he said.
But the key point with Griffin's case and why it's an important precedent, despite everything Your Honor said, it is not a precedent of this Court. But Griffin's case provided the backdrop against which Congress legislated the Enforcement Act of 1870 when it first provided an enforcement mechanism for Section 3.
It did away with it later.
It did away with it later. But
that has nothing to say with respect to what Section 3 means. Can we get to the issue, which is, I think, one that I go back to that I started with, and very briefly, what sense does it say that states can't enforce Section 3 against their own officials? I think logically those are two separate issues in my mind. Can states enforce the insurrection clause against their own office holders, or can they enforce it against federal officials, or can they enforce it against the president? Those are all three different questions in my mind.
And the answer to all three of those questions turns on whether this Court agrees with the holding of Griffin's case. If Griffin's case is the proper enunciation of the law, then a state cannot do any of the things Your Honor suggested unless Congress gives it authority to do so.
So a non-presidential decision that relies on policy doesn't look at the language, doesn't look at the history, doesn't analyze anything than the disruption that such a suit would bring, you want us to credit as presidential?
Because Congress relied on Griffin's case when it enacted the Enforcement Act of 1870 and established...
So, Mr. Mitchell, if I may interrupt, but just to clarify, I mean, this sounds like your reply brief, where it sounds like you're not making a constitutional argument. You're really making a statutory preemption argument. And is that what you're doing here? You're not saying that the Constitution gives you this rule. It's the kind of combination of Griffin's case plus the way Congress acted after Griffin's case that gives you the rule?
That's exactly right, Justice Kagan, because we have implementing legislation. Congress took up the invitation provided by Griffin's case and established writs of quo warranto in the 1870 Enforcement Act, later repealed them. The only enforcement legislation that's currently on the books is the Insurrection Criminal Statute, Section 2383. And when Congress made all of these decisions, the initial enactment of the Enforcement Act in 1870, the repeal of the quo warranto provisions in 1948, all of those were made with Griffin's case as the backdrop.
Please.
Well, the understanding was that these congressionally established remedies would be exclusive of state court remedies. So there's not an express statement of preemption in these statutes, but there didn't need to be because Griffin's case provided the backdrop.
And if I could just understand the argument a little bit better, suppose that we took all of that away. You know, suppose there were no Griffin's case and there were no subsequent congressional enactment. What do you then think the rule would be?
So just as a matter of first principles without Griffin's case, it's a much harder argument for us to make because normally, every other provision of the 14th Amendment has been treated as self-executing. What we would argue, and that's hypothetical that Your Honor has suggested, is that there are practical considerations unique to Section 3 that counsel in favor of a rule similar to what Chief Justice Chase spelled out in Griffin's case. And it goes to, I think, the policy concerns he talks about, where this was a case, Griffin's case involved a convicted criminal who was seeking a writ of habeas corpus on the ground that the judge who tried his case was an insurrectionist disqualified under Section 3. And Chief Justice Chase realizes that if he enforces Section 3 in this situation, it would nullify every official act taken not only by this particular judge, but by anyone who is an insurrectionist or arguably an insurrectionist under Section 3.
Well,
and that was
why do you need those consequential concerns, though? It kind of seems to me that what Justice Kagan is getting at is why don't you have an argument that the Constitution of its own force, that Section 3 of its own force preempts the state's ability not necessarily, I think not, to enforce Section 3 against its own officers, but against federal officers, like in a Tarbell's case kind of way.
So there could also be an argument that's more limited. You're suggesting there may be a barrier under the Constitution to a state legislating an enforcement mechanism for Section 3 specific to federal officers. We could rely on precedents such as McClung that says that state courts lack the authority to issue mandamus relief against federal officials.
Well,
and
why
extend
aren't
that
you
principles
making
here.
those arguments?
Because that doesn't get us – that Griffin's
that
case
only
goes,
gets you out of state court, doesn't get you out of federal
right.
court.
And also the holding of Griffin's case went well beyond that because Chief Justice Chase said in this opinion, which again provided the backdrop for the congressional enforcement legislation, that states had no role in enforcing Section 3 unless Congress was to give them that authority through a statute that they passed pursuant to their Section 5
But your arguments –
No, please, go ahead.
I was just going to add one last thing. I think your argument's a little broader than that because I think if we accept your position that disqualifying someone from the ballot is adding a qualification. Really, your position is that Congress can't enact a statute that would allow Colorado to do what it's done either, because then Congress would be adding a qualification, which it can't do either.
No, I don't agree with that, Justice Barrett. Congress is not bound by the holding of term limits. Term limits only prohibits the states from adding additional qualifications or altering the Constitution's qualifications for federal office. It does not purport to restrain Congress. So if Congress were to enact implementing legislation that authorized the states to exclude insurrectionists from the ballot, we believe that would be valid enforcement legislation under Section 3, with an important caveat. There has to be congruence and proportionality under this Court's precedent. So
why would that be permissible? Because Section 3 refers to the holding of office, not running for office. And so if a state or Congress were to go further and say that you can't run for the office, you can't compete in a primary, wouldn't that be adding an additional qualification for serving for president? You must have been free from this disqualification at an earlier point in time than Section 3 specifies.
I think the answer to your question, Justice Alito, depends on how you interpret the word enforce in Section 5. And some members of this Court, such as Justice Scalia, thought that enforce means you can do nothing more than enact legislation that mirrors the 14th Amendment's self-executing requirements, and you can't go an inch beyond that. That's not the current jurisprudence of this Court.
No, well, all right, you have to decide whether it's congruent and proportional, right. And we would get into the question of whether that would be congruent and proportional. Well, let me shift gear a little bit. I take you to argue, and I think this is right, that the term self-executing is a misnomer as applied here.
Yes,
very often when we use the term, what we're referring to is the proposition that a particular provision of the Constitution or a statute in and of itself creates a private right of action. That's not what the issue is here.
No, that's not the issue here. And sometimes the phrase self-executing is used that way. The only thing I would add is sometimes it's used in a different sense. With self-executing treaties or non-self-executing treaties, the issue is whether that treaty has any force as domestic law whatsoever.
Right. But I don't see what is gained by using this term, which is used in different contexts, rather than directly addressing what's involved here, which is the question of who can enforce Section 3 with respect to a presidential candidate. The consequences of what the Colorado Supreme Court did, some people claim, would be quite severe. Would it not lead to the possibility that other states would say, using their choice of law rules and their rules on collateral estoppel, that there's non-mutual collateral estoppel against former President Trump. And so the decision of the Colorado Supreme Court could effectively decide this question for many other states, perhaps all other states. Could it not lead to that consequence?
I don't think so, because Colorado law does not recognize non-mutual collateral estoppel. And I believe the preclusive effect of the decision would be determined by Colorado law rather than the law of another state. But I think your question, Justice Alito, gives rise to an even greater concern, because if this decision does not have preclusive effect in other lawsuits, it opens the possibility that a different factual record could be developed in some of the litigation that occurs in other states, and different factual findings could be entered by state trial court judges. They might conclude that, as a matter of fact, that President Trump did not have any intent to engage in incitement, or make some other finding that differs from what this trial court judge found.
Yeah, exactly. So in this decision, the trial court in Colorado thought that it was proper to admit the January 6th report, and it also admitted the testimony of an expert who testified about the meaning of certain words and phrases to people who communicate with and among extremists, right? Another state court could reach an opposite conclusion on both of those questions.
Certainly. Other states could conclude that the January 6th report is inadmissible hearsay. They might also conclude that statements within the January 6th report were hearsay, even if the report itself is not. And they could certainly reach a different conclusion with respect to the expert testimony of Professor Simi. Perhaps in another state we would have time to produce our own sociology expert who would contradict Professor Simi.
Should these considerations be dismissed as simply consequentialist arguments, or do they support a structural argument that supports the position that you're taking here?
I think they all mutually reinforce each other. We have an argument we believe that is sufficient to dispose of this case just based on the meaning of officer of the United States, as well as the argument we're making based on term limits. But all of the consequentialist considerations that Your Honor has suggested are additional reasons to reverse the Colorado Supreme Court, although we don't think it's necessary to get into consequences because the law is clearly on our side.
You keep saying term limits. There are other presidential qualifications in the Constitution: age,
yes,
citizenship. There's a separate amendment, the 22nd Amendment, that doesn't permit anyone to run for a second term.